All right, so we finished 12, and we are going to postpone, no, sorry, we finished 11, right?
15.
15.
Jumped over. We finished 15. 12. Oh, it's 12. Which one are we not doing? It's 12 we're not doing, right?
Correct.
Okay, okay, got it. So we're now on 36. Is that right?
Yes.
Yeah, we're going to, just for the record, we decided that we needed more analysis done on the issue of where on the process of approvals of permitting and other regulatory process, where they have to be before they get to us. We decided we needed to do more research on that before we discuss it. So we will go to number 36, which is Commissioner Stebbins.
Yes. Question 36, if MOUs and other agreements may be part of an applicant's proposal to the commission to demonstrate their commitment to key evaluation criteria, how should the commission weigh these agreements and enforce them in the coming years after the license is awarded? I believe this question somewhat grew out of some early interest that at least one of the state's Convention and Visitors Bureau approached us about with respect to their interest in creating a partnership, creating a relationship with potential applicants in Region 2. They had organized a subcommittee. The subcommittee created an RFP that they wished to share. The result of those RFPs would result in the crafting of an MOU or an MOA between the Convention and Visitors Bureau and a potential licensee. Again, to forward and promote the principles of the statute towards job creation and having a positive impact on local small business and travel and tourism. I didn't find anywhere in the statute, especially under sections 9, that detail requirements of the application, or 15 or 18. Is there any mention of local agreements, MOUs, beyond obviously the host community agreements, surrounding community agreements, and any agreements with impacted venues? Other studies, ask for workforce development plans, affirmative action plans, and marketing plans, and those are all requirements of the applicant. Under Section 18, the Commission, obviously, the language says the Commission shall evaluate and issue a statement of findings on how each applicant proposes to advance the stated objectives in this section. It would appear that, at least from my perspective, critical documentation from an applicant to demonstrate their ability to complete any of the objectives might result in some type of document, a plan, an MOU, being included in their application, again, to demonstrate and show the Commission they have a clear understanding, so we have a clear understanding of how they're going to demonstrate to meet their objectives. We received 6 written submissions on the questions. MAPC was somewhat silent on MOUs and evaluation. They did get to the issue of enforcement of these agreements. Responsibility for enforcement ultimately lies with the Commission. However, input and guidance from the community mitigation subcommittees, which will be created, or an optional local community mitigation advisory committee, should be used to enforce and track mitigation as outlined in the agreements. Sterling Suffolk commented yes, yes, and yes. They believe that such agreements can be evaluated in the licensing process only in the context of the record established in connection with a particular application. With respect to a licensee's performance of such agreements, SR notes that Commission's general oversight power enables it to field complaints from either party. Experience in other jurisdictions suggests parties will not be shy about bringing such issues to the attention of the Commission. Commission not need spend time and resources at this stage to develop or produce or to monitor compliance. Joshua 11 commented violation of any agreement should result in license suspension and severe fines. Martha Robinson commented no comment other than answers given above about strengthening enforcement. Paul Vignoli said violation of any agreement should result in license suspension and severe fines. Shefsky and Freilich, on behalf of the City of Springfield, said if an MOU or other agreement is an integral part of an applicant's proposal, then the MOU or agreement should be given appropriate weight. Such MOUs and agreements should be enforced by the party with whom the applicant has made the agreement. Further in the statute, we talk about after granting a license, Section 23 requires Class A and B licensees to issue an annual report to the Commission explicitly stating its progress on meeting each of the stated goals and stipulations put forth in the licensee's original application. Inability to meet stated goals within a reasonable time frame shall result in additional fees as deemed fair and reasonable. Yeah, this portion of the statute could be read to allow us to review their progress on components of their application, including any submitted MOUs that they use as testimony to their ability to complete the statute's priorities. In the end, I came down as recommending that we answer this question in the affirmative, that MOUs can be included in an application, again, specifically to attest to an applicant's ability to demonstrate an ability to meet the objectives under Section 18, and that for the time being, we defer enforcement measures until later if appropriate.
Questions, thoughts, reactions?
Strikes me as a sound approach to it. There's a whole variety of, be good, a signed agreement is good evidence that they've worked out details of meeting some of these objectives, and we can, a whole variety of enforcement mechanisms that we can consider as we issue the license. So, strikes me as a good approach.
I would agree with that. I have a question that is not necessarily part of this question, if you will, but perhaps it's the next step. And as we ponder criteria, or the details behind the criteria in Section 18, will this commission be grading, if you will, or evaluating the adequacy of some of these MOUs? And there was a little discussion to that effect yesterday to some degree. I just kind of wanted to throw it out there in this context. But I do agree with this analysis, and I think it's a relevant piece of information, if nothing else, to be part of the submission. I wonder that once it's been submitted, will we be in a position to be evaluating the adequacy?
I would say sure. I mean, just like we're evaluating everything else, right? I mean, to the extent that it's within our ability.
Well, we had a discussion relative to, a lengthy discussion, I would pose, relative to local control. And if at that point we were to send it back as inadequate, I would just like to understand it for my benefit.
The local control concern stops when the application gets to us. I mean, I think we are empowered to assess and review everything. And as we've said before, if we think that at the local level they did something that we thought was a mistake, we've decided to let them make it, so long as it doesn't, impede our process. But when it gets to us, we would certainly take it into consideration.
Well, let me just give a hypothetical, and we need not decide this now, perhaps, but maybe we should. A local tourism board does an MOU with a developer that has a certain set of conditions. We're going to do X, Y, Z, says the developer, to help tourism in this area. And we look at that MOU, and do we then have the power, and if we have the power, are we going to assert it to say, no, that's not good enough, you got to go back and put terms X, Y, Z in that MOU? At that level, I'm not sure. We probably have the power. I'm not sure whether we ought to do it. But that's also hypothetical, that if what we do have the power to do is say that this MOU, if this is all you have to promote tourism, is insufficient to show a commitment to meet the tourism standard of Section 18. I mean, there's no question about that.
Which was the question he was asking. Can we evaluate the merit of the MOU in accomplishing whatever the criteria is it's meant to accomplish?
I understood something a little bit different. I understood, can we pick apart a specific MOU and say that MOU is inadequate? Let's say we got 5 MOUs that are designed to hit the tourism piece. We surely can consider whether the 5 do it, and we can, or not. I mean, I don't think there's any doubt about that. But the question is, that I thought you were aiming at, can we pick apart a specific one of the 5 and say this one's inadequate, you got to make a better deal with entertainment venue A? I have doubts about that.
I would have said we certainly could. I don't know why we.
Well, then we differ.
Yeah, and I pick up on your question to be somewhere in assessing how well an applicant is trying to address the criteria in Section 18. I think, my feeling is, if the MOU says we promise to work together and it's signed by 2 people, that's not going to provide me as much evidence or as much detail for me to be able to make a judgment as to whether they're going to be able to meet the goals and priorities of the statute, as opposed to somebody who's lays out an MOU with a detailed plan and, sharing resource, however detailed it may get. But I think to answer your question, I think we should evaluate that. I'm not sure I want to go back in and dissect it and send something back. It comes in, it's part of the application, it should be part of the application. I'm hoping that such a document will be helpful to our evaluation of an application, but not necessarily be in a position to go back and open it up and make recommendations.
I would agree with that. It's just a way of evaluating one applicant versus another. If one is much stronger in that area, they'd get higher marks in that area, where someone else may. But
Fair enough.
I guess if that were the one in every other area, they were the strongest applicant, but this was weak, could we at that point say, look?
Or if we only had 1 bidder and we didn't like it, could we make them go back because we didn't think it implemented the intent of the law?
Yeah, I think we're saying the same thing in different ways. I really don't disagree with the macro view of that.
There is a little bit of a larger point, and on this whole local control stuff, I've evolved in my thinking about it to the point where my sort of sense is that all of the rights which are initially granted to the local community, subject to the standards that we've now come up with about impeding our process or impugning the integrity of the process, that I'm leaning, and if we get to this, I've made a recommendation on whether we should approve the summaries, the concise summaries. I lean towards giving them a lot of rope, because I think that's what was intended, but I've been doing it thinking that when it gets to us, we ultimately do have pretty broad latitude to implement our judgment. So that, if we really thought, even a host community agreement, that we thought we're not going to put out minimum criteria, but if a host community agreement came to us that we thought just simply didn't do the job, it just seriously overlooked, and that there were going to be other effects that were not mitigated adequately. Again, take the easy case, and there's only 1 bidder, that it would be complicated, but I had been thinking that we do have this backup right to pretty much intervene on anything we think we need to intervene on to get the law implemented properly, including saying this host community agreement is inadequate. Not that particular one raises a question about whether they need another referendum and so forth, and there's criteria for that in the law and so forth. But I just, as a general principle, I lean towards giving them a lot of rope. But it's partly because I believe we have a very strong ability to have a corrective mechanism when it finally gets to us. And to the extent that we have that less, then I'm inclined to give less rope.
No, I agree with that schematic, and the real question is how we exercise the power that I think we have.
Right, okay, good. All right, so I think we're agreeing.
Question answered.
Okay, so do you want to frame your motion,
Sure.
Commissioner?
I move that the commission answers this question in the affirmative, that MOUs can be included in an application, and we defer discussion or development of enforcement measures until a later date.
Second.
Second.
Further discussion? All in favor?
Aye.
Opposed? The ayes have it. Commissioner Stebbins, I guess. Policy question 38.
Sure. Question is, as part of an applicant's goal to impact small business, what information should the commission require? And you see the relevant sections. All throughout the statute, and I won't go through it, but all throughout the statute, Section 1, Section 9, Section 15, Section 18, there are continual referrals to presenting plans for outreach to small business. In some cases, those small business enterprises are identified with a focus on minority and women and veteran-owned businesses. We have the ability to issue a statement of findings on how the applicant plans to promote small business in host surrounding communities, contract with local business owners for provision of goods, et cetera. As I started to weigh into this question, this probably in some way goes back to an issue that anyone in business development would think about, is requiring we first understand the definition of small business. The U.S. Small Business Administration creates a spreadsheet that lists small business size standards matched to industries. And the size standards are, for the most part, expressed in either millions of dollars in sales or number of employees. And though most industries qualify as small businesses with up to 500 employees, I would harbor a guess most of us around this table or in the Commonwealth would consider a company with 500 employees as a large employer. Minority, women, and veteran-owned businesses are obviously identified with appropriate registration with their state and federal agencies. I'm not suggesting in answering this question that we create a definition for small business, but again, I think we acknowledge that established standards might lead to a different perception or definition of small business, and hopefully our applicants would see that as well. But that we encourage our applicants to be creative and aggressively seek suitable vendors in the immediate area and report the impact they may have on other area businesses required under the statute. I'll jump to some of the comments that we got. MAPC, to best identify potential impacts of small business. A detailed market analysis should be performed, including analysis of potential secondary displacement. Joshua 11 said the host city should submit a detailed proposal on small business impact. This must include independent evidence from other casino sites around the country showing how casinos do or do not have a detrimental impact. Sterling Suffolk also commented, said, we note that the Gaming Act requires an applicant to study its impact on small business. Moreover, an applicant must provide the commission with a marketing program. They also talk about a collaborative process identifying and contacting key businesses, advertising, media, community partnership organizations, chambers of commerce, informing the local small business community through meetings and presentations, conducting outreach to small business. Martha Robinson said the document info needed is stated in the PDF. Looks good. Chambers of commerce are unreliable. Shefsky and Freilich for the City of Springfield said the Gaming Commission should require applicants to submit information concerning the expected impact of the applicant's project on small business located in the host and surrounding communities and how the applicant expects to mitigate such impact. statute, again, does call for 3 documents for the licensee's application related to small business impact, and I've outlined them there. In considering the information that we're already going to request, and at the same time considering the position that we posted for the Director of kind of Supplier Development and Workforce Development, I think a helpful piece of information would be asking a license applicant for information relative to their outside spending categories, you know, landscaping services, limousine services, kind of where they might have an opportunity to contract with a local vendor. Information in these categories would be helpful to this staff person we are looking to hire, to make sure that an applicant is thoroughly looking around the host community and then maybe fanning out from there to find suitable vendors in the surrounding communities that are even broader within the gaming region. And Mr. Chairman, as you know, we brought a team together to try to make sure that if an applicant finds a small business that for some reason is just not at the capacity level they need to be at to be a suitable vendor, that we want to try to help that local business get there and actually work in partnership with a prospective applicant. I recommend that we respond to this question by highlighting for potential applicants that information which is already requested by the statute, and additionally request an applicant's expected outside spending categories and projected amounts would be helpful information for us to have.
Thoughts or comments?
I think what you're saying is the law covers this pretty well, and you're just looking for us to ask for additional information on how they plan on using those local folks. Is that right?
That's it.
Okay. Like a good recommendation.
You're not supposed, it wasn't so much how they're going to use the local folks, that it was how much business are they going to have available.
Right.
By various categories.
Right.
Yeah, because, which we will definitely be, we will be getting that earlier up front, because we'll be, as you said, we're going to be proactively trying to tie local people into those categories. So how many flowers you're going to buy, how many lunches, you know, et cetera.
Exactly.
Yeah. Okay.
Again, you know, we're hoping that when we say impact on small business in the statute, that has a positive connotation instead of a negative connotation to it. But I know Michael Pollack from Spectrum wanted to stick around, and if he had any thoughts or comments on this topic, I know this is right up his alley, so.
Just very briefly, there's, in our experience, there's 3 ways in which a casino applicant or a casino licensee can impact small business. One is in what they purchase in goods and services. The other is working with them in helping to share in money spent by visitors. And the third is just in general economic conditions through employment and other areas that it can then help local businesses through increased spending levels. And each one of those areas would require its own sort of plan and its own sort of concept as to how they advance it. In New Jersey, we developed something. It's since been found unconstitutional, but it was called the Equal Employment Business Opportunity Plan. It was found unconstitutional for the equal employment aspects of it, not for the business opportunity plan part of it. But what those plans did, it required, these weren't applicants, these were licensees. It required licensees to put forth very detailed plans as to how they were going to, in part, incubate small business, for example, or help or develop cross-marketing arrangements with small businesses. And I can say that because it did encourage creativity in terms of developing it, there was a definition of putting forth a good faith effort to develop these creative plans. It did work well, at least while it was in existence. It did work well. Like there are opportunities to be creative and to help incubate small businesses.
Great.
Thanks, Mark.
Other thoughts or questions or comments?
Just a minor one, so I won't be lengthy. As a reminder, we'll be undertaking the research agenda piece, and that has an economic impact dimension, and at least I always thought of it as one of those sub-dimensions of the economic impact is that of small business. So I suspect we will be gathering a lot more information to this effect. And we could require more of that in the future of our applicants.
Great. Anybody else?
No, I think it's a sound plan. I think it's a sound approach.
I like the additional idea, your suggestion. Also, Mr. Levin had a interesting point about when we are testing people's assertions, that looking at how they've done at other sites in other places is a good idea. I mean, we should be doing this on everything we do as much as possible.
Right.
Because it's one thing to say it, it's another thing to do it. I thought that was a good suggestion. Did you move? No, not quite. Would you like to move?
No, I can move again. Again, I move that the commission respond to this question by highlighting, again, for potential applicants, they probably know this already, that that information which is already requested, and additionally request an applicant's expected outside spending categories and projected amounts.
Second.
Further discussion? All in favor?
Aye.
Opposed? Ayes have it. Okay, question number 44, Commissioners Zuniga and Stebbins.
Can I start with that, Tina Kraft?
Go for it.
Perhaps by coincidence, this question number 4 that I shared with Commissioner Stebbins was similar to one question number 4, in the sense that it's a broad question, and one where we don't necessarily have a straightforward recommendation, one in which we, or at least I, think that we should think of broad definitions, and I'll get into that in a minute, but ask questions in a way that tease out sufficient level of detail to inform in the best way possible. But the particular question is relevant to Section 913 and 1818. And those sections are both from the content of the application and the evaluation criteria, rather broad studies, if you will, that start to get to economic benefits, local, social, regional, environmental impacts, impacts on the local and regional economy, the cost to host and surrounding communities, and to some degree we've dealt with a little bit of that in other questions. And estimated municipal and state tax revenue. There are others for Section 18 as well. Some of these has a cross purpose. In Section 18 does talk about the total amount of investment, infrastructure improvements related to the project, economic benefits to the region, and in particular, plans for assuring labor harmony. Let me just get to the general comments, and they were equally broad, but not necessarily off point. Sterling Suffolk goes on to list a number of impact or benefits that are related. I won't list them all here, they're included in the packet. Shevsky and Froelich believe that the reports and studies in these sections are self-explanatory. The MAPC suggests that an environmental notification form and the criteria should be a baseline process and one that should be completed prior to issuing a license. They go on to mention that additional housing, economic development, and social service studies would need to be evaluated, though I believe that that by definition, this comment by definition can only happen in the future. MGM and Springfield lists a couple of points, economic impacts, should be limited to direct and indirect taxes, wages, employment, and economic activity, and that the projections of the gaming revenue should really be a piece for comparing applicants to other municipalities. The town of Bridgewater states that economic impacts for existing local retail and restaurant, traffic impacts on local roads, and reports on social impacts and impacts to public safety, all of which are, I would pose, part of the broad definitions on those two sections. As I think it's been mentioned in the past, a good example is one of economic benefits, that the Commission should accept economic benefits as broadly as possible, but ask questions and require information that tease out the most detail in a favorable manner to facilitate the analysis. I would say that's the general thought, really, regarding this section. I did include in the memo, we did include in the memo the last point relative to plans for assuring labor harmony. And those questions could be posed very detailed, and I put them in here for consideration, or they could be posed very broadly, like the statute says, and allow respondents to submit what they will. Did you want to expound, or?
Yeah, I think you, just under section 18, which again has to, last provision having to do with plans for assuring labor harmony. I think it was calling for any information of violations of state labor laws within the last 10 years, and obviously an applicant could also provide any information that they have to demonstrate labor harmony in other jurisdictions where they may operate.
My reaction was to this was that the statute's pretty comprehensive. It gives us pretty good guidelines. Do you see us a need to flesh this out more in the regs?
Not necessarily. I mean, there are, this is the same issue we have in a lot of these areas where, yes, there are broad guidelines, and a lot of them are fairly, fairly well inclusive. And then what is the balance between allowing for creativity among the proposals within those broad parameters or being more specific? I don't know that it would be adding that much to have additional regulations to do this, but to the extent that we, creatively might be able to come up with something that would give the direction to the applicants and the licensees so they know what the attitude of the commission is in fulfilling those broad parameters would be worthwhile.
Okay.
I agree with all of that. All of the categories in this statute in 9A 13 and 1818, save one, have a target, a definable target. Labor harmony, what are you going to do? Traffic impacts, what are you going to do? Maybe. But economic benefits to the region and the Commonwealth is really broad, and I just wonder whether without some guidance, we're going to be able to compare apples to apples when we get the final applications from the applicants. That's who gives you applications, I guess. And I wonder if it wouldn't be worthwhile to take not the detail that we've got, for example, for labor harmony, where we look at track record and signed agreements and all that, but take a look at the criteria or the kinds of things, and I think this was part of your suggestion, that we're interested in, and leave other, but at least have a basis for comparing apples to apples as we look at the economic benefits that the applicant sees.
I'd agree with that. Instead of the applicant having to act in a vacuum and not know precisely what would be a favorable activity on in your minds or not so favorable, this gives them that kind of guidance.
Right.
I
And it
think-
could
I
be
think
anything
it-
from estimate of job creation, why, estimate of satellite revenues from tourists,
Right.
hotels,
Right.
why,
Mhm.
and the like.
I think you shared with us some information from Pennsylvania that had an economic analysis requirement. I think it'd be pretty easy to come up with a list of, again, some of those, everybody answer to these criteria and other, which you seem fit, but to your point, to give us a chance to evaluate apples and apples as opposed to.
Correct. Agree with that.
Yeah, and I think the detail, just to pick on one example, job creation. From my perspective, I'd like to understand all the assumptions and analyses
Right.
behind
Right.
a number, even if it's just one number. Hopefully, there's many numbers. There's jobs created, there's jobs preserved, there's indirect jobs,
Right.
there's multiplier effects.
Right.
But even if we're asking about ultimately one number, we'd like to understand and communicate that we don't just want one quick calculation, because this is what you saw in another jurisdiction. Tell us in detail what are your assumptions relative to multiplier effects and things like that.
Well, that's an excellent point, and that would apply to all the criteria, whether you specify some sub-criteria or not. All of the submissions should justify whatever conclusions they're coming to.
So I guess we do, are there more conversation about this? I guess we do need a motion.
Well, I don't know that,
Maybe we don't.
that there's
Yeah.
much of a motion, but for the fact that we will continue to refine the criteria like we have said and issue guidelines relative to what we will see as information that we may require.
Okay, and maybe we could ask you to take a step at fleshing that out a little bit. Some of the stuff that Suffolk had was good.
Yes.
Yeah, by you, I meant the team.
Yep.
Okay, that's it for the questions that were here for today, but we said we would go further if we have time. We do have some time. Commissioner Zuniga and I have to be out of here at 5, quite sharply, but we still got an hour and a half. So if we can get to the point where we don't need to meet tomorrow, I'm sure everybody would find that delightful. I know you folks would love to come, but,
Just a point of administration, would we need to cancel that after the end of this meeting,
Yeah.
that notice?
well, we aren't gonna know for sure. I think we're probably gonna make it, but we aren't gonna know for sure. So, but Janice and Jamie are expecting to get the word, and Elaine, if we're gonna cancel tomorrow, we'll have to do it by a few minutes of 5. So like at 4:30, we'll talk about it. We don't need to make this a different meeting, Commissioner. Yeah, we said we would go ahead if we could. So why don't you, let's see, these are,
I have 4 questions, Mr. Chair, and you have 1, correct?
no, do I have one?
So what is this one that was just handed to us?
Oh, that's, yes, yeah,
Okay.
that's a new one, yeah, right.
Okay, so do you want me to take my 4?
And the other two,
They are no longer on the list. They
22 and 39 are gone?
The 22, and are those the first two on the
Yeah.
list? Yes. Those really are subsumed, in my view, in the putting together a schedule of requirements and evaluation criteria that we talked about the other
Okay,
day.
fine,
So,
all right. So let me just deal with that first of all. So 22 and 40 and 39 are subsumed in, was that question 5, basically?
Yes.
Yeah. the elucidation of evaluation criteria. Okay. So then we get to the 4 from Commissioner Cameron. We have not had a chance to read these. Is it better, do you think, should we just take a few minutes and let everybody read them? Or you want to just walk us through it?
I think I can walk you through it, and
Okay.
you could be looking at the memo as we speak.
Okay.
Policy question 41 is what process should the commission use or require for testing gaming equipment? And the legislation does speak to this. The commission shall utilize the service of an independent testing lab unless the commission otherwise determines it's in the best financial interest of the Commonwealth. The laboratory must be qualified and approved by the commission to perform the testing of slots and other gaming equipment. Look at applicable data for independent testing laboratories from agencies in other states, which we're fortunate enough to have had the benefit of our consultants who have looked at all of that data. Our strategic plan also speaks to this. They are agreeing that the testing be done by outside laboratories, and they suggest we look at the standards that are developed by Gaming Laboratories International as well as BMM. Those are the 2 biggest labs used all over the world. There are a couple of smaller labs though also that have a portion of the market. Public comment. Sterling Suffolk Racecourse also recommends that we use the 2 biggest labs, and we utilize them for our testing. In looking at all of this and in looking what other jurisdictions have done, I think it would be wise for the commission to promulgate regulations for licensing independent testing laboratories. In other words, we shouldn't pick one lab. We should have a set of comprehensive set of standards that all those laboratories must abide by. We open it up and say that we are soliciting the service of qualified laboratories. These are our standards, and that we should evaluate all those who apply and those who meet our qualifications. We will leave it up to the operators to decide which of the labs they choose to use to have their equipment tested. This is a method used by some other jurisdictions, and I think rather than picking one lab or 2 labs, this makes the most sense. Here are our standards. We are soliciting services. We will obviously have an expert assist us with that evaluation. We certify these 2, 3, 4 laboratories, and then we allow the operators to choose where they have their equipment tested. That's my recommendation.
What's the argument for letting the operators pick which ones they want to use rather than us saying?
Because they all have, they all use one of, let's say, 4, as it is now, and it's allowing them that flexibility. They're certified by us, and you can use their services if you choose to, rather than picking one lab over the others who may be equally qualified. This is a way of
Well, we could pick more than one lab if we wanted to, but it would still be, I don't understand we can pick as many labs as we want to use. What is the benefit, or what's the argument in favor of letting the casino pick? That feels funny to me. Yeah.
One of the economic advantages to the casino is that there'd be price competition as between the various labs, so casinos can get just as good a service for a lesser price if they are allowed to negotiate with the different labs in terms of which ones they want to use.
But that makes sense. But why doesn't that create problems similar to the problems we've seen with auditors? In other words, the allegiance is to the
Well, that's a regulatory issue that the commission would be overseeing those labs to ensure that you would have, and our recommendation would answer this, that there would be staff on the commission that would be able to review the report of the lab, so that you make sure that they have complied with your standards of testing each of the elements of the games that are required to be tested. They're not going to be able to retest them, but they would make sure that those games have been reviewed in that way. And your background investigation of the lab itself would also give you some assurance. These labs would be service industries who would be licensed as casino service industries. So their integrity and their good character would be all part of that evaluation. And the combination of the background investigation plus the overview, to the extent you're able to do it, of their results would give you the assurance you need that they're going to operate properly.
There could be, or there will be, for all the reasons that Guy alludes to, controls similar, not dissimilar to the situation that you allude to, Commissioner, in which the reporting is to the commission, not necessarily to the operator. And that establishes an inherent control, I would argue, relative to that potential for conflict, if you will.
Bob reminds me, too, that another factor that plays into this is that the manufacturers themselves can't afford to have their games corrupted. Because if that word gets out, then their name is sullied and their games are less worthwhile.
So you're saying that mitigates the potential for a conflict of interest?
All of those factors, I would think, mitigate the potential for a conflict of interest.
And is the only benefit to having the operator do it that maybe they can negotiate a better price?
Well, they may also feel that one lab is better than another. They all may meet certain standards, but competition, one casino may have a view that they've used a particular lab for a long period of time. They have an ongoing relationship. They trust that lab. They know the work that that lab does, and they would prefer to use it. It's
counterintuitive to me. It just feels it feels like it's.
How would we do it otherwise? 1, 2, 3, 4. You go to this lab. You go to that lab. You go to that lab. How?
Well, we could do it. There's any number of ways, and we could, depending on what we thought of the labs, but it could just be random, which would sort of seem to make sense from a security standpoint. But we also could talk with, once we've qualified everybody, qualified the labs, there'd be nothing wrong with talking to a provider, to an operator, and saying, if you've got a preference here, what do you think? And we think about it and we decide if we think that is okay, fine. But to give, we could still honor the benefits that you're talking about, but it would be our choice. And if we felt for some reason like we didn't want to have the operator doing it with the lab because it felt funny to us or whatever, then we would still have that right.
But
the process doesn't always go, by the way, clarify, the process doesn't always go from the casino to the lab. Very often the process goes from the manufacturer to the lab. The manufacturer would send the game to the whatever labs are licensed in Massachusetts, could go to any of the licensed Massachusetts labs, and then those games would be certified for use in Massachusetts. There'd be a menu of those games that the casinos could then pick from, knowing that they've already been approved. So there are two ways that it goes. One, that a casino wants to buy a game that hasn't yet been approved, so it's sent to the lab. The other, that the manufacturer establishes a menu of potential games that they've had approved that casinos can buy.
If I could add one thing.
Sure.
In jurisdiction where Guy and I actually serve as regulators, we get from the larger labs an inventory on a periodic basis of all machines that have been submitted by the whole universe of manufacturers. And those machines are tested to the standards that have been established. All of the casinos in a particular region, well, in the country actually, get those documents indicating that these machines from this manufacturer have been certified as, being in compliance with all of those applicable guidelines. They are then given to the various operators. and the operators have them. So as a commission coming in Massachusetts, the operator will probably provide you with certifications that were from the lab, but were generated by the manufacturer and the lab, all of whom have been licensed, all of whom have been backgrounded and vetted, so that the entire process is covered. The net result is that the report that you get will be something that will be of international consequence in the event there's any mischief involved in any course of the process, because number one, the manufacturer can't risk that type of reputation or any discovery of any lab irregularities. The lab itself, its entire reputation is involved, and the licensing of all of those. If they get a license, for example, if you find a particular lab is in violation and you sanction that license, that reverberates through their entire network of customers and literally can put them out of business. And
So
that's
these outfits are like Underwriters Laboratory.
exactly highest stakes possible for all involved in it. So to give you that assurance, if it's
You know, there is no Arthur Anderson anymore, you know, because they colluded, you know, and who would have thought that Arthur Anderson would collude? It's such the separation of those kinds of relationships is just such a natural part of keeping a system clean.
But in that example, the auditors continue to be picked by the companies that are audited, with the control, I would argue, that they now report not to management but to the board of directors, and it's not like now an SEC, let's say, imposes an auditor on a public company. That's not, I would argue that's the parallel here, in which us as regulators may not want to impose a lab on an applicant.
Well, the same argument, the casinos are also audited, but I'm not sure there'd be a suggestion that the commission should designate only certain auditors that can audit the casinos. They choose their own auditors, and you know, the possibility remains that, you know, someone's going to misbehave. But the controls that are placed on it, the auditors are licensed, the audits are audited by the commission. The same applies to these slot labs.
I started us down this trail. I'm not sure that the auditor analogy is the right one anyway, because these are far less judgmental
That's
kinds
true,
of
too. That's right.
testing. Right?
Objective.
You hook these things up to a variety of things. You play them 6 million times and you see if it defaults.
Right.
Has there ever been any trouble, you know, any monkey business, any labs?
Not the labs themselves. The only real problem was that I'm aware of was the Nevada State lab, where one of its employees, it was not the lab itself and it was not the state of Nevada, but one of the employees who, because of his employment, had access to certain algorithms that manufacturers were using, left the lab, then used those algorithms to predict the outcome of games, and he was caught. But that's what the labs themselves and the operation of the labs, to my knowledge, have never been accused of being co-conspirators with the casino.
One other thing, the process itself starts with that initial, obviously, development, delivery of the machine for testing and the testing processes. But even on the rollout of the machine, even when the machine arrives at the operator's location and so forth, before that is put on the floor, there's a whole series of testing that's done, including a device known as a Cobotron, as well as now more with software testing, that allows for the machine to be verified that it's within the exact industry specifications as set forth in the testing and so forth before it hits the floor. And then in addition to that, there's additional audit that is capable by both the commission, the manufacturer, and you know, the net result is that before the public ever gets to push a button, pull a slot arm, there's been a verification process that started from the initial manufacture of that machine all the way down to when it arrives on the floor. And it's, you know, we've grown to be very confident in the system. It requires vigilance continually. It does require industry standard safeguards and standards that are applicable. and expertise on your staff that can immediately respond to any questionable areas, whether it's a public question or whether it's a regulator question or one of your floor inspectors. And that'll be a whole body of individuals that'll be distributed among the different facilities to be available for that. So, for what it's worth, as consultants, we can say to you that the system itself has proven to be secure, and certainly you want to, enforce the most rigid standards possible.
That would be the key for us, correct? Is those standards that we
Yes.
come up with. I really like the idea of competition with all of the labs who are, rather than picking one lab. And I think this is far superior than having our own lab and trying to train people.
And when you
The
say
games change too quickly, correct?
Yes.
When you say the standards, the standards are fairly uniform.
Mhm.
So, I mean, there won't be any, I wouldn't anticipate any real peculiar standards that are special to Massachusetts.
Just as an aside, and you may have been invited to this, we could certainly, intercede and see if we could arrange for your visit to one of these labs to see the thoroughness of it. I think you might find it fascinating.
Well, in due time, that would be interesting, but I don't think that would bear.
Oh, it's not bearing on this, but just to give you
I think
a
we
more
would like
detailed
that.
sense of it.
We can always change our mind on this. I mean, it's not the end of the world. I mean, that last sentence to me is kind of gratuitous. It doesn't really go to what the policy question was. You don't really have to have it in there or not, but if people feel strongly about it, if we bring in a licensing person and they have a different idea, we can listen to them and think about it. So, I mean, it's, any more conversation?
No.
Do you want to structure a motion?
Okay, I recommend, make a motion that the commission promulgate regulations for licensing independent testing laboratories and creating a comprehensive set of standards by which those laboratories must follow. And we should license all qualified testing laboratories. I will leave out the last piece of this motion at this point, so we can
If you're okay with
think
that,
about
yeah.
that further. Yeah, I'm fine. So right now, we want to, the motion is to promulgate the regulations for independent testing laboratories, create our own set of standards, and license all those qualified testing laboratories.
Second. Any further discussion? All in favor?
Aye.
Opposed? The ayes have it. One down. Number 24.
Next question is, what information should the commission require in respect to an applicant's description of its minimum system of internal procedures and administrative and accounting controls for gaming and any simulcast wagering operations? Again, the law, Chapter 23K, does speak to this. Establishes that the applicant must have a minimum system of accounting controls and administrative and accounting controls for gaming and any other simulcasting, just as the question asks. These controls must be certified by the applicant's chief legal officer and chief financial officer. Controls must be adequate and efficient, in compliance with generally accepted accounting principles, conform with any additional standards the commission requires. The applicant must submit those controls at least 30 days prior to commencement of operations, and they cannot be altered without the commission's approval. Our strategic plan speaks to this issue in a very detailed manner. And it talks about the goals of these controls: creating an accounting record, conducting transaction and access assets only in accordance with management's authorization, seek check assets against records, supervise all games and departments. Again, it speaks to the conformity of the minimum internal control standards, recommends the commission consider whether it can promulgate general regulations while maintaining comprehensive minimum standards. This is the key here to this question is, and we've been discussing this with many of our questions, which is, can we keep the regulations somewhat generic, but yet have a set of internal control standards that are very specific? That would that would call for, that would allow the ability to change as needed, rather than continually promulgate new regulations. So that really is the key to this question. Our consultants have laid out 27 very specific areas of regulation and internal minimum control, as you can see there. And I won't go through all of them, but definitions, accounting records, forms, financial statistical reporting, records retention. I mean, the list is extremely comprehensive of the things that we should require the licensees to have as part of their plan that we will approve. The public comment on this matter is SSR, Sterling Suffolk Racehorse, that we should adopt this plan for minimum internal control standards sufficiently in advance of the commencement of casino operations to permit gaming licensees to craft their systems in compliance with the standards that we put out. Obviously, the gaming licensees should be precluded from commencing without the commission issuing written approval for these internal controls. They recommended Missouri and as an example that they liked. They noted that New Jersey has engaged the local industry in those standards before they changed anything. And it's my recommendation that we, again, it gets back to, can we do this? We promulgate a general set of regulations, and then as outlined, a very detailed set of standards which allows the flexibility to make changes as needed. This bifurcated approach will allow the Commission to avoid any delays created by regulatory changes and be able to quickly update its system of minimal internal control standards when necessary. Using these regulations and standards, casino operators will then create their own set of internal controls, and the executive director will have the power to accept and reject internal control standards developed by the casinos.
Comments?
I like the idea of allowing the casino to develop standards. I think the commissions, within broad parameters, and this list is a comprehensive list, the commission's objectives and the casino's objectives are pretty much aligned in most of these things. But I don't understand the difference between this, in the recommendation, between the first sentence and the second sentence. The first one says, we promulgate a general set of regulations governing the types of controls that they must have in place, and then we should create a comprehensive and detailed set of minimum internal control standards to supplement the regulations. I don't understand.
I think this list of 27 categories would be the standards, correct? And the regulations themselves would be would not be this inclusive. In other words, if there's something that had to change, we wouldn't have to change a regulation.
Yeah, I understood your recommendation this way, that there would be regulations that would establish the framework within which a casino's procedures would have to be established, and that the commission would review the casino's submitted standards to make sure that they complied with the general framework of the regulations. That's what I understood you to be saying. Not that the commission necessarily would be promulgating both the regulations and the standards. They would be approving the casino standards that they've promulgated in accordance with the commission's regulations.
Well, can I ask for an example then? We have this helpful list and comprehensive list of areas, if you will.
Right.
That's taken from the strategic plan. So we have a regulation that says you have to establish internal controls to deal with the following 27 areas.
Right.
Now, what more would the regulations say, apart from you create them, submit them to us, we approve them. When we approve them, you can't change them without giving us 48 hours notice or...
All right. Well, I think, for example, with financial and statistical reporting,
Right.
you would establish the types of reports that you want.
I see.
Okay?
Okay.
And then they would provide you with a system that shows how they were going to develop those reports, how they were going to be, how they were going to be overseen, that they wouldn't be all done by one person, that they would be people in inconsistent positions to be able to review them, so that they were, that there was separation of duties.
But, okay, but
That kind of thing.
if you go down that path, Guy, what's left for the casino to do? You have to have...
No, I'm saying the casino does, is doing, they do that. You're telling them we want a cage report, we want a credit report, we want,
I see.
and then they would tell you how they were gonna do that.
Who reviews who watches who.
Right.
what
So
kind
does this second sentence, is that a typo? Does that mean the casino would create a comprehensive, I don't know what those two.
Where are you?
Under the recommendation, the same question Commissioner McHugh asked. I didn't understand the distinction between these either. And
I read that to mean that the commission would, in terms of creating it, they would be the ones who would be approved. They approve it, so it can't be done unless you say that it's approved, it could be done. I mean, they'll submit those procedures to you, and then you'll tell them whether those procedures are adequate or not adequate. You create the, the ability on their part to implement them.
So if we said in that second sentence, the commission should create a regulation requiring approval of a comprehensive and detailed set of minimum.
That would be, if that's what the commissioner wants.
Yeah, well, yes, and I think the way I was looking at this was, we need to give them a detailed set of standards.
Right.
So we wouldn't be saying here, this is exactly what you have to do, but these are the standards. We'll be looking at all of these things.
But are the standards these things, or is it more than that?
Well, the standards would be all of these things, but maybe with a little more detail,
That's right.
correct?
That's right.
That's how I understood
That's right.
this to be. These are the categories, but
Okay,
now
good.
we have to fill this in with more detail.
Let me give you, if I may be helpful, a couple of examples. If you look at, let's just pick one, number 11, drop box removal and transportation account room, okay? Casinos have, depending on their physical layouts, a variety of ways of transporting from machines. There's those that still take tokens or whatever else, which are really shrinking right now, but have different methods of transporting from a machine to a account room. Okay, some may be by a vehicle that 2 security guards will walk next to. Some will have 3 people, 2 people, whatever else. All of those details would be filling in. That would be the population of this general rule that would say the casino operator shall create drop box removal and account room transportation standards that'll be acceptable and approved by the commission. You'll then populate that with detailed internal controls, essentially.
We will?
Of that.
Or they will?
No, they will.
They
And they
will.
will submit it to you for your consideration and review and approval. And then you can go right down in each one of these. Except the next one, 12, acceptance of cash at gaming tables, counted in assurance. How many signatures are required? Is it the security guard and the table supervisor that we're doing? Each one of these has nuances and details that go on down, all the way down. Your regs would be,
Yeah, I think to supplement that, there would be some additional rates, not just listing these 27 items.
Right.
I mean, within any of those 27 items, control over sensitive keys. What are the sensitive keys? You would designate in your regulations what you consider to be sensitive keys. Then they're going to have to decide how they're going to be controlled. Information management system responsibilities. Now, what information are you going to just talking about the casino, the casino gaming information management systems, your hotel information management systems? What is it that you want the casino to be able to submit to you? So there are subcategories. within
Okay,
these.
so the first question, so what you just described is the 27 plus. Would
27
be
plus.
the general set of regulations governing the types, the first sentence governing the types of controls. It sounds like the second sentence should say that, what it means is the casino will submit and the commission will approve a comprehensive and detailed set of standards to implement those regulations.
But I don't think the regulations would go into that much detail. That would be more the standards.
No, that's what I'm saying.
Okay, I'm sorry, so the first
So the-
sentence, when you said that, if that's the regulations themselves, which
That's right.
would be much less detailed.
Yeah, that's to be 20, that's 27 plus the additional stuff that he just got through
No,
talking.
that would be more the standards, not the, you don't want all that detail in the regulations.
No, I think Steve's saying the 27 plus,
Yes,
all written the way they are in those generalized fashions.
yes.
Would be your regulations.
With some additional specificity, but not much.
Yeah,
And-
you gotta have sensitive key controls.
Right,
Sensitive keys are X, Y, Z.
Right,
Right.
right.
Right, but the standards that would go underneath that, your so-called internal controls would be the detail, the flesh, that would be added.
And they would be written by the casinos and
Casino,
approved by
approved
us,
by us.
but not in the regs.
Not in the regs.
Not in the
Not in the
regs.
regs.
Because as Commissioner Cameron's point, that these procedures need to be revised fairly regularly, and you just can't do that in a regulation system.
When.
Right, so,
Go ahead, sorry.
okay, so it could be worded differently, is I think what makes sense to me too, is,
The casino shall submit and the commission shall approve.
yeah,
A comprehensive and detailed set of minimum control standards to implement the above-mentioned regulations. Now, just a curiosity, Sterling refers to Missouri having some mix, some minimum internal control standards.
Right.
Does that refer to that which we are now saying? the
That's
casino-
that's even more detailed than what we're talking about. Yeah, those, minimum is kind of a misnomer. There certainly can be supplemented, but Missouri has them, the National Indian Gaming Commission has minimum internal control standards for Indian
Which
gaming.
which are they? Are they the ones that we're now saying the casino shall submit?
They're
Or is it our?
they're
is it
more the
reg?
ones that the casino should submit
Should
than they
submit.
are the ones that than the
Okay,
state
so the
would
use of,
promulgate.
so the use of minimum internal control standards here is parallel to what Missouri does with their mix. Our second sentence
Yeah,
refers to.
Your second sentence, yes.
Your second
Your second
Your
sentence.
second sentence, yes.
Which says minimum internal control standards.
Louisiana has what we're talking about here.
Yes, that's correct.
And it looks like New Jersey also has done some.
New Jersey is more, it initially, in New Jersey, they just imposed very specific standards on everybody. And as the years have gone on, they've been retreating from that step by step. Until now, it's more, you give it to us and we'll approve it type thing.
And again, this will be fluid. You know, after the properties are operating for a period of time, you'll have a continual examination of this, and you'll get proposals from a casino association saying that this works, this doesn't work, we can be more efficient doing it this way, and you'll certainly give due consideration to that.
Right. Okay.
any more questions? Thank
I
you.
have no basis on which to make a judgment. If they think it's right, you
Well,
think it's
that's
right.
why I
Right,
did
right.
rely heavily on
Yeah,
the
right.
strategic plan on this one,
Right,
because it's
right.
just an area where,
So the-
okay, so I'm prepared to move that the commission should promulgate a general set of regulations governing the types of controls that casino operators must have in place, and the casino shall submit a comprehensive and detailed set of minimum internal control standards that supplement the regulations.
That implement.
That implement, well,
Well, either-
it supplements
All right,
what we've
whatever.
said too. Supplement the regulation for which the commission shall approve.
Second. Further discussion? All in favor? Aye. All opposed? Ayes have it.
Number 40,
42.
what happened to 41? Is there,
In this one?
That was 41.
oh, was that 41?
That was
we just did?
41.
Sorry, okay.
Okay,
42.
42.
Sorry, yep.
Gaming.
What should the length of licenses issued to employees whom the statute requires to be licensed? What should the length of those licenses be? Okay, so the law does not establish a length of license to be issued to the employee. The commission, the language in the law is established the term of a key gaming employee and a gaming employee. Those should be licensed. Regardless of the length of the license, give the commission the power to condition, revoke, or suspend that license when the licensee fails to report changes of a conviction or fails to comply with any of the licensing provisions. Temporary licenses may be given to employees, and those licenses statutorily expire in 6 months unless the commission determines otherwise. Also, the statute categorizes employees into key gaming employees and gaming employees, and then gaming service employees. And the law speaks to gaming service employees need only be registered, not licensed. And the commission has the power to create different durations of the length of the licenses of key gaming employees and gaming employees. The strategic plan recommends staggering the issuance of employee licenses for an even rate of activity for initial license periods and for the renewal of those licenses. The strategic plan does not speak to the length of the license, which is the essence of this question. Public comment on this matter is from Sterling Suffolk Racecourse, and they point out that the Commonwealth's licensing requirements are modeled after New Jersey prior to 2011, and at that time New Jersey had a 5-year length of license with the license holder, which would undergo a renewal investigation equally thorough to the one conducted at the initial. Since then, New Jersey has modified it, and every 5 years, but they do not go through another investigation at that time. They also talk about Nevada having a 15-year license or such shorter term as the commission deems appropriate. And so in speaking to both our gaming consultants as well as other jurisdictions, both new and established, even those who have a much longer license, the recommendation is that we do not, as a new gaming commission, we do not go for a long license. For example, New Jersey has gone to a longer period, but that's after many years of being established, knowing the process, knowing the players, knowing the individuals. Many commissions have started with a 2-year license. That really is can be an administrative burden. In speaking to everyone, the consensus really is a 3-year license to start. That we issue licenses to gaming employees and key gaming employees, and we're talking about the difference there of it's the type of background investigation, it's how much control, how much money, to talk about the difference. And I have some charts here that in the next one we talk about we differentiate. But for now, just we're talking about a recommendation of a 3-year license for both key gaming employees and gaming employees. This duration would create a balanced trade-off between the need to ensure public trust in gaming and the avoidance of unnecessary administrative burden. Obviously, we have the power to condition, revoke, or suspend a license when the licensee fails to comply. And after 3 years, my recommendation is that we should evaluate that 3 years. Is 3 years the proper time frame? I'm recommending it is to start with, and then we can evaluate it after 3 years. As part of this recommendation, the commission should not require licensure of gaming service employees, but those employees will be registered with the commission. So what we're talking about is a full-blown background investigation with a license, and we're talking about criminal checks, query checks, and some key questions of registrants. And those are the folks we're talking about. the gaming service employees, we're talking about the folks who service the rooms in the hotels. They do not have access to sensitive materials or the gaming floor necessarily. Those are the folks that are considered the gaming service employees. And that's the group that we're talking about registering. Again, it's criminal checks, it's query checks, it's key questions that they have to answer truthfully.
Credit and drugs?
Excuse me?
Credit and drugs?
When you say drugs, are you talking about a drug screen?
Yeah.
For a register?
For gaming
You know
service.
would do that.
Yeah, not the commission. Yeah.
Who would do this?
The employer, at the casino, the employer usually, almost always have pre-employment drug screening.
Yeah.
And what about credit checks?
Credit checks would be part of the
Our
licensing.
background.
The licensing, but not the
For
registry.
registration.
Not the registration.
That's what I meant for registry.
For registration, no. Very often, the people that you're recruiting to have, the whole idea of creating employment,
Right.
a lot of them will have credit.
Yeah, right, exactly. And drug too, I would think. Right. But, so we're taking the position that we don't think that there needs to be drug tests for gaming service employees. If the facility does it, fine, but if they don't, it's okay
Yeah,
with
it's
us.
typically not part of best practices with registrations. Yeah. Or licenses, yeah.
Oh, you don't do drug tests for licensing either?
That's up to the employer.
And I'm sorry, what's the split on credit checks? Is there a split?
Licensing.
Licensing, yeah.
Yes.
Do credit checks for
Credit
licensing?
checks for licensing.
So
Doesn't
that-
mean that the credit history is disqualified. It just
Yeah,
means it's
taken
checked.
into consideration.
Right.
How
it's
severe?
not disqualified?
Depends on what, it's a fact-sensitive evaluation.
I mean, examples, the thousands of these, there might be medical histories, medical bills that have not been paid that may create issues, but,
Right.
And again, the public policy in creating opportunities for
Right,
employment.
that's what I was thinking about.
These
Yeah.
all- these
Yeah,
all have,
right.
I think we're
credit
doing
histories.
with the Holyoke Community Training
Mhm.
Institute.
Yeah.
it's not exclusionary.
Right,
Case-by-case basis.
Right.
right.
Again, the 3-year is basically, it gives us enough without overburdening. Many of them have gone to 5, but I just, right, as a new commission, I think we need to be especially careful, and then we can reevaluate after 3 years.
I would agree with that approach. Sounds sensible. Sounds like you've done research on the notion of startup mode in which
Yes.
we are in, which is important, and also considering the burden, the administrative burden. So the staggering is also a great recommendation.
I agree.
All right. How about if you, let's see.
Shorten that up
Well, you
for a
could
motion?
just move to accept your recommendation as written.
Well, I move to accept the recommendation as written.
Second?
Second.
We can give this to you to see. Any further discussion? All in favor?
Aye.
Opposed? Ayes have it. Okay.
So my last policy question is, last for this round, is policy question number 43, and what non-gaming vendors should be excused from the licensing process. To quickly summarize the legislation, the law, it defines gaming vendors as those that supply a gaming licensee with equipment related to gaming. Similarly, the section defines non-gaming vendors as those who supply goods not directly related to gaming, such as construction companies, vending machine providers, linen suppliers, garbage handlers, maintenance companies, limousine services, food services, suppliers of alcohol beverage. And what the law says is non-gaming vendors shall register with the commission. and also provides that the commission may require licensure of non-gaming vendors falling into one of two tiers based on the amount of business the vendors conduct with the gaming licensee. The lower tier is $100,000 worth of business over 3 years. The higher tier is up to $250,000 in a 12-month period. So I put a chart in here which just talks about those different numbers. And as you can see, we're looking at the gaming vendor, that's a licensed position. The non-gaming vendor, we're talking about registration, or the amount of the non-gaming vendor would be a license or a registration, depending. And I have some explanation here. Well, first we'll go to the public comments. Paul Vignoli, all employees, vendors, and vendor employees should have extensive background checks and be licensed without exception. The integrity is important. Anyone that has access to non-public areas. Airport employees are an excellent example. SSR believes that publicly traded non-gaming vendors that do business with gaming licensees and applicants should be excluded from the regulatory process entirely. Non-publicly traded companies should be required to register with the commission, with such registration being valid and effective unless and until the commission revokes, suspends, or administratively removes the approved vendor. And it points out that we have broad discretion in this matter. Mohegan Sun encourages the commission to establish a system that supports the use of many Massachusetts-based businesses as possible. In this regard, many of the goods and services that Mohegan Sun project, as well as the other gaming projects in the Commonwealth will use, will be non-gaming related. They suggest the commission establish a process that does not discourage or restrict these businesses from participating in the business opportunities by creating non-gaming licenses, thresholds, or systems that discourage their participation. I think we understand where they're going. Okay. I think what we need to do is balance those interests. We certainly need to have an idea of who's doing business, how much business, what kind of access they have and control they have. So what we're talking about here is requiring licenses for non-gaming vendors conducting over $250,000 worth of business in each gaming, in each year with the gaming license. As the legislation requires, the Commonwealth will only require registration, not licensure, of non-gaming vendors conducting under $33,333 of business per year over a 3-year period, or less than $100,000 over a 3-year period. For that group of non-gaming vendors over $100,000 in that 3-year period, and under $250,000, we're looking at a heightened registration. So what we're really recommending here is kind of 3. As we just explained, all gaming vendors will be licensed, and the non-gaming vendors will be registered, one of two. And I was really listening to understand the nuances of the difference between registration and heightened registration, and this is done commonly in other jurisdictions. Again, a registration, and that's the group making under $100,000 in a 3-year period. It is criminal, query, and some key identifiers, some key questions that we ask them to answer honestly. I know you gave me a couple of good examples of that, Guy or Bobby. A couple of the questions that we'd ask just for a basic registration.
The civil litigation history.
Yeah.
And just the background of the business operation, bankruptcy history, civil litigation history. If it's a regulated industry, have they ever had any licenses revoked or suspended, those kinds of things.
And then for the heightened registration, which is those folks that are making up to $250,000, I know, Bob, you explained to me some additional questions.
Yeah, not unlike what Guy just said, you'll go a little bit further in terms of their business, depending on the type of business, there may be some follow-up questions on, for example, your initial asking may say, who are the operating officers, or who are the managers right now? When you go a little bit further up the chain in terms of monetary involvement, you would then move towards, other persons in the company, for example, and expand it a little bit further. You're just essentially enhancing your initial set of questions to take it to another level, because the exposure is a little bit more. And likewise, financially, you're asking for more additional information from them. And it's a graduating process, essentially, that results in you having a little bit more information. I also might add, as a practical matter, that basic identifiers you get in that initial registration process enables modern law enforcement to have an immediate set of identifiers that can be accessed. And with the access today to public information even, the quick checks that can be done and are done as a matter of course are a lot more comprehensive than they were even 10 years ago. Great.
And this will require the commission to implement a system that keeps track of the amount of business that's being conducted by any individual vendor, so that you have the vendor registration process, so you have a.
Well, wouldn't this have to be done on a projection basis? You're not gonna have somebody come in and do work for a year, and then you decide later on, after you've audited their.
It's done on a contract basis, so as soon as the casino enters into a contract with a company that is reported, the company has to register, and then when you are approaching a threshold, the commission notifies the vendor that if they anticipate going over the threshold, then they're going to have to apply.
It's a monitored process.
Right, but that means that a construction company who's gonna do 250,000 or more doesn't have to get licensed until they get to the 250,000.
Once they enter into the contract is for over $250,000.
So that's what I said, so it's a projection, it's not an actual cash
Well,
flow.
it's a legal obligation that
Once,
casinos
yeah.
entered into.
Yeah, okay.
And over 250,000, we're talking about a license.
Yeah, right.
So which really does give us the ability to license, even though they're a non-gaming vendor, they're making that kind of money, we think it's important to license them.
Right.
Why the averaging?
I'm sorry?
Why the averaging over a 3-year period?
Because
That's a statute.
That's our law. That's what they tell us to do.
The statute says regularly conducting over 250, or regularly conducting over 100 within a 3-year period. So it does contemplate both both the contract and a look back. If somebody is on a regular basis, and it's permissive, we don't have to do that. But, so this would be a policy that we would do this, i.e. we would license them, give them heightened registration or nothing. So we have the option of not doing any of this. Or we have the option of requiring a license for the people who are doing more than $33,000 a year on a regular basis. So your recommendation is that we exercise the permission that we have to require a license for anybody doing over $250,000 a year.
Correct.
And that with respect to the people doing between 33 and 250 a year, we require a heightened registration.
Correct.
And that with respect to the people under 33, we do nothing.
No, it's a registration.
I mean, a registration.
Yes.
And that we do that for those people who have meet those criteria on a regular basis, or I would assume by a contract which is going to show that they're going to do it. A 3-year contract for $1 million would trigger the thing automatically.
What about Suffolk's point about publicly traded non-gaming vendors? What's the standard up?
There are different jurisdictions handle those different ways. The justification for reducing the scrutiny of publicly traded companies has typically been, well, they're regulated by the SEC. Recent history may dictate that regulation may not be consistent with what you may want to regulate those companies. So the mere fact that they're regulated as a publicly traded company is a factor in determining whether or not you can waive their, whether you could waive their need to qualify, to be licensed. But it shouldn't be the determining factor that you waive their license.
So
there is an authority that you have to waive licensing in particular cases.
Okay.
And typically that standard is if they're otherwise regulated by a public agency to the same standards that you regulate them. So if you feel that the SEC does that, you can waive it. If you don't, then you don't have to.
Right. Okay.
My only question here is that the statute does say regularly conducting over $250,000 worth of business with a gaming licensee within a 12-month period. If there's one occasion on which a vendor conducts more than $250,000 worth of business in a year, do we have the power under the statute to require them to be licensed? If there is one occasion on which a vendor does more than $100,000 worth of business with a licensee over a 3-year period, do we have the power? We certainly have the power. Do we have the power to do anything more than have them register as a non-gaming vendor? I don't know the answer to that.
Read again what it says. So,
The statute says all non-gaming vendors, basically, shall register with the commission and shall produce such information as the commission may require, provided, however, that the commission may require any vendor regularly conducting over $250,000 of business with a gaming licensee within a 12-month period, or $100,000 of business within a 3-year period to be licensed as a gaming vendor. That's what it says. Regularly conducting is the trigger for the licensing requirement. The question is,
I don't know, I don't know the definite answer to that. I guess I would, if it's strictly read so that regular means it has to be done more than once, then you'd be licensing no one for the first year.
that's right.
And that doesn't seem like it would be the intent of the legislation to do that.
And so I.
Wouldn't that be regular if it's the first year? If it's the first year and they're doing that kind of business, that is regular because it's only been a year.
It's from the beginning.
That's the way I would interpret that.
I understand that, but I'm trying to figure
I
out how.
think appellate court Judge
my former
McHugh might
friend-
have a problem.
My former colleagues might interpret it.
Yep.
Yeah, and they may be two different things.
It sometimes is.
Pardon me? Yeah,
It sometimes
Oh,
is.
It often. So I think this is, from everything that I've learned from a public policy standpoint, it makes sense to have people doing this volume of business with a gaming licensee, license. And so I'd favor proceeding with the recommendation as stated, but I do have this caveat, and we will see when we issue the regulations whether there is some considerable concern, and that'll give us another opportunity to do some more research as to the proper interpretation. So I'd favor this, but I think everybody ought to understand that we have may have an issue.
There are a lot of gray areas in this.
Right.
I may have told this before, but we got a situation where, and every jurisdiction distinguishes between gaming and non-gaming, but even that, what you would think is a clear line, is not always so clear. One casino had realized that the dimensions of a roulette ball were exactly the same as the dimensions of a particular toilet valve. So they started buying their roulette balls from a plumbing supply company for a nickel apiece. And because they were roulette balls, they were gaming equipment, and this plumbing supply house that was doing about $1.50 worth of business was being required to file as a gaming service, which really didn't make a lot of sense. But really there was no option with gaming. So there are all kinds of aberrations in this, but you have to try to make your best judgment.
I don't think we need a regulation to cover that.
I move that we accept the recommendation as written.
Second.
Further discussion? All in favor?
Aye.
Opposed? Ayes have it. It's 25-5. We could deal with this issue now, but,
Has this appeared on any agenda?
yes. Wait, on any agenda? No. I was preparing it for tomorrow's
No,
agenda.
I understand,
yeah,
I understand
right,
that. And since we're down to one, and since this one, having quickly looked at it, appears to be relatively straightforward, I would recommend that we deal with this on Tuesday.
Yeah, I was gonna say the same thing. Right, okay, good.
Good recommendation.
All right, do we have a motion to adjourn in a celebration?
So moved.
All right, thank you all.
Thank you.
Meeting adjourned.
Thank you.
Thank you very much. Thank you guys for hanging in with us.
Yeah. Thank you.
Yeah.